conditional green card holder, which is expiring in February, mid-February, and divorce is in process. So that gets a really troublesome spot. When you're doing a removal of conditions, when you're in a process, so let's back up and see what removal of conditions is for those watching new. If you're getting your green card based on marriage to a U.S. citizen or green card holder, if the green card is approved within 2 years of your marriage date, they issue you a 2-year green card instead of a 10-year green card. The reason is, after 2 years, when the card's about to expire, they want you to submit another application for I-751 to say that this relationship was real and prove it. Now, typically people are still in a relationship and they may have children, they may have property together. There's all these documentation they can submit, but sometimes they get divorced. Now, you need to have all the documentation to prove your relationship, so you need to accumulate documents to help prove it. Maybe have personal statements or something like that, and you may have the interview. If you're going to get divorced, USCIS cannot make a final determination on the case, and they can deny it if your divorce is not finalized by the time they adjudicate it. So in your scenario right now being December, and you have your green card expires in February, and your divorce is not finalized, you can submit the Form I-751 as a solo single in the sense of not having your spouse sign it, but you will get a request for evidence if by the time you submit the case, your divorce is not finalized, and you'll get a request for evidence saying, hey, we want the final divorce certificate before we can approve the case or move forward, and hopefully by that time you'll have it. Now, when you do what's called the case, what do they call it? It's not a waiver case. For I-751, solo, without the spouse, there is no necessarily end time to do it, but you really want to file it before the green card expires to be safe, and then just speed up that divorce and try to get it in so that when they ask for the divorce certificate, it's there. If they do an RFE, you can potentially say, listen, let me come to the interview and I'll show you the divorce certificate because it's not finalized. Here's the court order showing it's happening. But it gets really messy, and that's the times you hire an immigration attorney. The stuff I just said right now is general information. I need to know more about your specific case, a lot of different factors, but I just want to give a general overview of the troubles that happen when you are getting divorced midway when you're starting or midway in the removal of conditions I-751 process. It's not clean, so unfortunately you're going to have to deal with some headache. Now you have follow-up with the question, if I get divorced before the decision is made, is that going to affect it? Well, that depends. Are you applying for citizenship based on a 3-year green card or a 5-year green card? If it's a 3-year, yeah, it's going to be a major issue. They're going to deny the case if you're divorced. So that's as easy. So when you file for citizenship based on marriage, a 3-year marriage kind of thing, you have to stay married and not divorced until after doing your oath ceremony or interview, oath ceremony, getting the naturalization certificate, then getting divorced. If you get divorced before that, it invalidates the 3-year aspect of it and becomes a problem. Now, if you've been waiting for so long, at the end of the day, yeah, so it's going to be a mess. Hopefully, you just did 5-year and won't have that problem. I hope you enjoyed this educational video. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.